We're speaking to Justice SN Dhingra, former judge of the Delhi High Court and one of the signatories of this open letter to the Chief Justice of India calling for suo motu cognizance of Udayanidhi Stalin's statements and action against him for his speech. Thank you very much, Justice Dhingra, for speaking to India today. We wanted to ask, sir, what exactly is the content of this letter that has been sent? Why do you want the Supreme Court to take cognizance of this statement by a political person?
You see, Supreme Court has been very vocal in respect of hate speech. And I consider that this is a speech which is considered by almost every citizen of India, every Bharatiya, that it is a hate speech because it strikes at the root of our existence itself. The Sanatana Dharma is a eternal dharma of this nation and this people of this country. Who the people might have converted later on to various religions, but the dharma, Sanatana Dharma, is the basis. I thus consider that it is a fit matter where Supreme Court should interfere and should take cognizance, because I know that the state government is not going to take any action, and other filing of FIR outside the state is of no use. Actually, that should not be there. The cause of action, although it's for entire country, but the state where this speech was made has a prime responsibility of taking action. But it is the speech, in fact, made by state itself. So it is the Supreme Court is the right forum where Supreme Court should initiate action and should bring the culprit to the law.
You don't think that those will have any on the statement, the action that has been undertaken? You don't think that is fitting punishment?
You see, this trend of filing FIR throughout the country, I think this is not good trend that you file FIR throughout the country and leave the state where the person is staying and has made the speech. I think that state has prime responsibility of taking action. Since I'm sure that state is not interested at all in taking action against its minister, so I and others consider that it is the Supreme Court who should either compel the state to take action or should suo motu take action.
But sir, if you see the orders that have been passed in the judgments that you've cited in your letter, the Shah Abdullah matter or the Ashwini Upadhyay or even the other hate matters, what the court has directed local authorities, the state authorities, it is their responsibility to take action against hate. Ultimately, even the court will have to then direct the state authorities, correct?
This is what I am saying. The court should compel the state, because in this case, state is not taking any initiative, neither there is any hope. The state where the speech has been made should take the action, and the person should be dismissed from ministership at least. The state is not going to do that, and that is why see this letter to Supreme Chief Justice.
So just one question. Uday himself has said he has not said anything wrong. That with removing aggressive.
I have not seen in my entire life that a criminal going to court and saying, yes, I have done a wrong. Even a murderer says, I have not done murder. I have not done anything wrong. I have been falsely implicated. This is the standard stand taken by every criminal in the courts and outside the court. There are very few persons who take courage to admit that, yes, I have done wrong.